I just want to ask her a question to get, like, figure out when to pass this case. All right, good morning.
Good morning, Your Honor.
All right, if the attorneys could place their appearances on the record.
Assistant State Attorney John Kalinowski for the state of Florida.
Kenneth Williams for the defendant, Justin Golden.
And Mr. Golden is present.
Yeah. Yes, Your Honor. We do have a partially negotiated plea, I believe, which would be a plea to the court as to count one. Basically, the only negotiation that the state has conceded is that we would be dismissing count two as part of the negotiation, but we will be scheduling a sentencing hearing.
Okay.
That is correct, Your Honor.
Yes, sir. What is the guideline score without scoring two?
The guidelines are, I believe it's 156 months. It should be written on the form, up to a maximum of 30 years.
Is count two the one that carries like some type of minimum or mandatory minimum? Or is it count one?
Neither one carries a mandatory minimum, Your Honor.
I thought one of them had a 4-year.
Count two, if it's considered a leaving the scene of a crash involving death, has a 4-year minimum.
This one does not.
This one does not.
Okay. All right, Mr. Williams.
Yes, Your Honor. On behalf of my client, we are prepared for my client to enter a plea. And, Your Honor, may I have a second with him because your requirement apparently does not admit a plea of no contest on the form. And I had discussed with him both last evening and before a plea of no contest. So I need to talk with him about that.
Yes, so there is an option for best interest as part of that. So the two sentences under plea of guilty allow him to either admit his guilt or to enter the plea of guilty because he believes it to be in his best interest, which, so if you want time to discuss that with him, I'll pass it temporarily, okay?
All right. Thank you, Your Honor.
All right, thank you.
Okay.
I want to make sure also, Mr. Williams, he's gone over the score sheet.
I'm sorry.
Have you gone over the score sheet with him and he agrees?
I have.
Okay.
Yes.
All right. Well, if you're in text communication with Ms. Wright, would you let her know that, was it Mr. Singleton?
Yes, ma'am.
Mr. Singleton's family was reaching out to her, and he's asked for time, and I'm asking her, like, around what time would she potentially know? Okay? Like, if she's not going to log on.
I can represent to the court that I did ask her, Your Honor, and she said the family has not been speaking to her, at least not recently, quote, end quote.
Okay. All right, well, see if she'll log on.
Yes, ma'am.
All right, can you put, okay, thank you.
She's logging on.
Okay. Can someone get a hold of Mr. Davis as well? Mr. Davis has 2 cases on. Can y'all put Mr. Singleton back in the chute? Good morning, Ms. Wright.
Good morning, Your Honor.
Thanks for logging on. I apologize for bothering you. So there's a gentleman by the name of, what's his first name? Antonio, okay. Antonio Singleton. And his case, I've been like in this holding pattern, and he keeps asking for time to like get a private lawyer. And he mentioned your name, and he said his family's been talking to you. And so I was reaching out to you to see if there was a time frame that you would potentially have a decision, but.
Your Honor, I have.
He said it's his uncle.
At least not recently. I haven't had any conversations regarding Antonio Singleton.
Okay, so he said it was his uncle that was reaching out. Okay,
I mean, unless it's been like a while ago, because I have a fairly good memory of people who call me. No one has
Okay.
called me regarding that person.
okay. All right, well, thank you for that, because one of them has been going on since like February. So I'm like, Mr. Singleton, what's your uncle's name?
He's right now.
Where is he?
Right now.
Are you Mr. Singleton's uncle?
Yes.
Okay. Have you been reaching out to Miss Wright?
What's this right?
Regina Wright, as a lawyer?
Oh, yes, his cousin had been reaching out to him.
His cousin. What's your cousin's name?
Chantel Harley.
Chantel
Harley.
Harley? No. Okay, I'm trying to figure out, I'm only gonna wait so long, okay? That's really where I'm at, okay? Because he's been in jail since February. It's September, okay? So I need a time frame, okay? Are y'all trying to retain a lawyer for him? How long do y'all need? And then this is it, because February is already too long in my mind, okay? And when does speedy trial run on this? Give me a sec, I'm talking to the lawyers, because he has a speedy trial date.
Your Honor, I believe it's August. It was August.
Okay,
Ross Wade.
okay. What is the date?
August 12th, 2025.
Okay, so speedy trial's already run. All right, Ms. Wright, I appreciate your time.
No
I guess-
problem, Your Honor. Your Honor, if Mr. Singleton is interested in hiring me, he can call me himself from the jail. My calls from the jail are not recorded.
Okay, did you hear that?
Yes, ma'am.
Okay, thank you. I appreciate your time.
No problem, Your Honor.
Okay, there's a lot of game of telephone, and I don't like that game. So what time frame do y'all need to like make some kind of decision?
2 weeks.
Okay. Did you hear that your speedy trial has already run? Yes or no?
Yeah, I heard that.
Okay. Well, I think there's a recapture period. Right, okay. I'm at the end, okay, of like when we're gonna start doing something on this case. I will give you the 2 weeks, okay? I need a solid answer at that point in time, not
Yes, ma'am.
ex-family member is trying to do whatever. In my mind, from February to now is more than reasonable to figure out if you want to hire whoever you want to hire, okay? But at the same time, okay, and uncle, what's your name? Mr. Harley, okay? Whoever you talk to, you need to let them know he has 2 cases, all right? A VOP and a new law allegation, okay? So, you know, I don't want Mr. Farquhar to keep representing him if y'all are gonna have someone else take over, but I need a solid decision, okay? I'll give y'all the 2 weeks, okay? Okay, yes.
Troy Pablo, the Office of the Public Defender. Ms. Daniels was here ostensibly for an appearance on a violation of probation. I didn't see an affidavit filed. There's a misdemeanor arrest for offensive battery. It's set to go through arraignment on September the 10th in Division Page. If it's filed.
Officer Williams, did you hear that?
Yes, Your Honor, I'm looking into it now.
Okay. Can you let me know, could y'all get it
Yes, I
done by next Monday?
Yes, Your Honor, I'll put it in.
Okay.
Okay,
So
thank you.
I'm going to pass her case until September 8th. Okay? 9 a.m., and that's for appearance on VOP.
Thank you.
Okay, Your Honor, thank you.
Thank you. Are you ready on Mr. Golden?
Yes, Your Honor.
It'll be just a moment. They've got to switch it over, but Yes, sir.
All right, he has read the plea form, he has signed plea form, I have signed the plea form as well, and on the plea form, he indicates that he is entering a plea of guilty because it is in his best interest, as outlined on this plea form and in the plea policy. So when the court addresses him, that is his plea.
All right, thank you. If you could hand the form to the clerk, please.
Yes, sure.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. The costs are not on the form. Do you, is the state requesting the standard $100 cost of prosecution?
Cost of prosecution, yes, Your Honor.
Okay, so the total amount of the cost would be $518 with the $100 cost of prosecution. Is your client agreeing to that?
Yes, and what time do we have to pay?
I don't know, it's generally like 90 days,
After release
yes.
or after the entry of the plea?
No, after release.
Okay.
And then he can always extend that time frame with the clerk's office if needed, or come up with a payment plan. Is there any application fee? I believe there is.
There is, it's a $50.
All right, and then so he has a court-appointed attorney fee of $50. Is there a 151 charge due to the child? I'm going to take that off. So the 151 that is on the form, does not apply in this case. Okay, so I'm going to take that off. What's the state's position on restitution?
I don't believe that there is any
Do you want me to reserve?
restitution, but we will be asking the court to reserve in case there is any.
Does your client have an objection to that?
No.
What is the victim information is not filled out on this form?
It is not filled out. We will be apprising the mother, who is the next of kin, of the sentencing date. We have been in communication with her about the potential of pleas. She has, as the court recalls, at an earlier court date, she testified on the defendant's behalf and said that she did not want him to remain in jail and did not want to be apprised of further actions. So we have not specifically requested her position on sentence, but we will be notifying her in case she would like to appear and give a statement at the defendant's sentence.
So, just my understanding from what you said, I'm going to check the middle box, which says victim has not been notified because she has requested not to be involved in the case?
That is correct, Your Honor.
Does the defense-
At least not kept up to date on
I will,
what's happening.
I will put that the state will notify her of the sentencing hearing and give her the option to appear and address the court.
We
Does
absolutely-
everyone have any issue with that?
Defense does not.
All right, so I'm going to do that. Give me a moment. How old was the victim's mother?
How old, Your Honor?
Right.
I believe she was either 19 or 20. I can get the court that specific information.
I'm going to write NOK, meaning next of kin.
She was 20 years old at the time. She would have turned 21 in July.
Okay. So what I've written on the form is that I've checked the middle box. It says the victim has not been notified because the victim's mother says she does not want to be notified of court proceedings. And then I've written down whether or not she wants to address the court. I've not checked anything. I said, however, the state is going to notify next of kin, meaning the victim's mother, of the sentencing date and allow her to address the court.
That's correct, Your Honor.
Is that any problem with that?
Acceptable, Your Honor.
Okay. Under days of credit, I'm going to put to be determined at sentencing. Is your client requesting a PSI be ordered?
Yes, Your Honor.
Okay. Okay. All right, Mr. Golden. I've gone over this form. You've heard the questions that I've asked your attorney in the state, correct?
Yes, ma'am.
Okay, so I've made additional notations on this form that comply with or basically memorialize the answers to the questions that I had to this form. Do you want to see it, what I've written on here?
No, ma'am.
You can if you want. I can hand it back. Do you want to see it?
Yes, ma'am.
Okay. So you'll see on the first page that underneath your sentencing time, that will be determined at the time of sentencing, okay? And then if you turn to the second page, on the second page, it says the 518, there's a number of court costs. The question that I asked the state is including the $100 cost of prosecution, that's statutory. So I've written in the amount that would be owed at the time of sentencing of 518, okay? And then also I've taken off a fee that does not apply to this offense, which was the 151 that was on the form is typed out. You see it's whited out. And then there's a $50 application fee that occurs when you go through first appearance, when you sign the form to have a court-appointed attorney. The application is $50. Additionally, you can see that I'm going to reserve jurisdiction for restitution, if any. If there is none, then I'm just saying that I'm going to retain this case if restitution is owed, okay? That's a completely separate process. Additionally, I've memorialized on there the questions related to the mother of your child, okay? She didn't want to participate. You were here for that, okay? I've written that on there. The state did not tell her that you were pleading today. because she didn't want to be notified, but they're going to notify her a sentencing date if I accept your plea, and she can address me at that time. That's what that sentence is down there.
Yes, ma'am.
Okay. You have any questions about what I've written on there?
No, ma'am.
Okay. All right. He's previously sworn, correct? All right. So the form that you've now looked over since this court's additions to it is titled Plea of Guilty with a Negotiated Sentence. It is partially negotiated, okay? You were charged by information with 2 counts, all right? You were entering a plea to the first count, which is aggravated manslaughter of a child. The state is dropping the second count, okay? So to that extent, you've negotiated with the state of Florida. The actual sentence, according to this form, will be determined by this court if I accept the plea. Is that what you want to do?
Yes, ma'am.
Okay. So have you signed this form indicating, as your lawyer has told this court, that you've read it, that you've asked whatever questions that you've needed, you've understood it?
Yes, ma'am.
Okay. And this is what you want to do?
Yes, ma'am.
All right. So I see your signature on here, okay, and I'm going to ask you a series of questions, and the majority of my questions come from this form, okay? And even though you said that you've read it and understood it, I want to make sure that you feel comfortable, that you can stop me when I'm asking you questions. If I say something to you that you don't understand, it is important that you understand what you're doing, okay? And that's the purpose of my conversation. So I'm depending on you to stop me if I say something to you that you don't understand. Will you do that?
Yes, ma'am.
All right. There are 3 ways, but the state is not dropping this case in total. So from your perspective, okay, there are 2 ways that you can basically dispose of a criminal case, all right? This is one way, which is a plea, okay? And by entering this plea of guilty, you are saying you don't want the second way, which is a trial, okay? So my purpose in asking you these questions and my purpose in saying these things to you is I'm going to describe what it is like to go through a trial. I'm going to ask you if you understand it and whether you are choosing solidly the plea as opposed to the trial. Okay, so by entering this plea of guilty, you are saying basically to me that you don't want a trial. Is that true?
Yes, ma'am.
Okay, so I'm going to describe it for you. If you chose to take this case to trial, what would happen is, first of all, you are presumed innocent of both of these charges, okay? And you don't have to prove anything in a trial, okay? It is solely on the state of Florida to prove the allegations that they've made against you beyond and to the exclusion of a reasonable doubt. Do you understand that?
Yes, ma'am.
That is the highest burden that is put to just regular everyday people that become jurors. Do you understand that?
Yes, ma'am.
All right. They would listen to the evidence in a case, and they are the people that determine, okay, if you wanted to take it to trial, whether you are guilty or not of what the state's allegations are. Do you understand that?
Yes, ma'am.
I, as a judge of the law, I would preside over the trial, but I don't make factual determinations. Instead, I make legal determinations, rulings along the way, okay? And so in a trial, you would be represented by an attorney, okay? The state would call witnesses. They would present evidence in a case, okay? And your lawyer would be there throughout the entire process, questioning or cross-examining the witnesses in front of the jury to expose whether those witnesses are believable or not. And I say it that way because lawyers are trained, especially defense lawyers, that if it is helpful to you, then maybe they argue that that portion of the witness's testimony is believable. And sometimes they argue that sometimes the witnesses are totally not believable. But that is the skill that your lawyer will be exercising through the course of a trial. Additionally, when the state puts on evidence, your lawyer can object to that evidence. He can do so pre-trial, or he can do it during the course of the trial. Questions, exhibits, he can try to stop the state from introducing that against you to prove your guilt. Do you understand that?
Yes, ma'am.
All right. And so I would be there, like I said, making rulings, okay? This whole thing occurs in front of you. And so I want to make sure that you understand that by entering this plea of guilty, you are giving up that process. You're giving up the representation of your attorney in that way. And additionally, you're giving up your right to confront witnesses that the state would call against you. Do you understand that?
Yes, ma'am.
Okay. And at the end of the state's case, I would turn to you and I would ask you, would you like to testify? I would start, and I'm going to tell you now, you have the absolute right to remain silent. It started when you were arrested, detained on this case, and it carries all the way through a trial, okay? You will never be compelled to testify in a case. And so by entering this plea of guilty, you're giving up your right to remain silent. Do you understand that?
Yes, ma'am.
Okay. So let me shift back to the trial. Let's say, when I asked you that you said, no, Judge, I want to exercise my right to remain silent. What I would do is I would instruct the jury that they can't think or even infer that you're guilty because you chose to exercise that constitutional right. Instead, I would point them back to the state of Florida and say that they are not to think anything about it and they are to look back at the state. You understand?
Yes, ma'am.
So the two solid principles you need to understand is that you're presumed innocent, okay? And you also, like, you don't have to prove anything, you don't have to say anything. Do you understand that?
Yes, ma'am.
All right, so by entering this plea, you're giving that up. In a trial, you could choose if you wanted to. Not that you're compelled to do so, but you could make a choice that I want to testify in a trial. And even if you chose to testify, I want to make sure that you understand what you're giving up is the consideration that the jury would give your testimony in weighing it just like any other witness to see if the state of Florida is able to prove their case. Do you understand that?
Yes, ma'am.
So even if you chose to testify, I hear it said all the time, oh, I got to prove I'm innocent. That is not true. Even if you wanted to exercise like a formal defense, like an alibi or self-defense, you still don't have any burden of proof. It is up to the state of Florida to disprove like a formal defense, like self-defense. Do you understand that?
Yes, ma'am.
Okay. And so, again, on the defense of your case, if you wanted to call witnesses in a trial, you have the same subpoena power that the state does. So if your lawyer subpoenaed witnesses, it doesn't matter whether they want to come to court or not, okay? You can compel their attendance and testimony through the use of that subpoena. Do you understand that? You're giving that up,
Yes, ma'am.
all right? And in my mind, that trial, okay, could lead potentially to a conviction, all right? It could. It could also lead to a not guilty. That's up to the jury, okay? But by entering this plea of guilty, you're giving up your right to appeal the conviction. Do you understand that?
Yes, ma'am.
All right, let me explain it a different way. So let's say you went through that trial that you say you want to give up, okay? The jury finds you guilty. You go through a sentencing hearing. I give you a sentence that you don't like, okay? And then you're off serving your sentence. You would do a direct appeal to the 5th District Court of Appeal. They would look over the entire proceedings. They would determine if those rulings that I made, okay, were correct or not, okay? They would also look at potentially the sufficiency of the state's evidence. They would look at anything that is preserved for their review. After they have looked over it, if they find any errors, if they find any mistakes in your conviction, your sentence goes away, the conviction goes away, it comes back to me, that is the trial court, all right? And then you get a second trial. And sometimes they will write an opinion, that's like instructions to me to say, Judge Kite, this was an error, this was an error, this was an error, give him a new trial. That second jury would not know anything about the first trial. You are still not guilty. You understand? You've preserved that not guilty plea all the way through that. So in short, if you took it to trial, the main thing is the conviction is not final until the appellate court says it's final. Do you understand that?
Yes, ma'am.
Okay. So you're giving up all that process. Is that what you want to do?
Yes, ma'am.
Okay. This piece of paper would be final when I say it's final. So you're stopping at the trial court. Do you understand that?
Yes, ma'am.
So this paper is saying, I wish to withdraw my prior plea of not guilty and and enter a plea of guilty because I believe it to be in my best interest. Okay? Is that true?
Yes, ma'am.
Let me tell you what that means to me, all right? And you tell me if this is what you are meaning, okay? Which that means that you've had enough time to go over what the state says their evidence is against you. You've had enough time to sit down with Mr. Williams and go through that, ask him the questions, get his perspective on things, and you are satisfied fully that the state of Florida would have sufficient evidence if this case were to go to a trial.
Yes, ma'am.
Okay. So this is saying, I'm not going to contest the facts, okay? I want to skip the trial, go to the sentencing, okay? And then I'm going to put it essentially in the judge's hands related to the sentence. You understand that?
Yes, ma'am.
Okay. I've looked through this docket, and Mr. Williams, I don't see any records of depositions that were taken.
I didn't take it,
All right, and you've gone over that with Mr. Golden.
yes.
Are you in agreement with that, Mr. Golden?
Yes, ma'am.
Have you had enough time to talk to them and investigate it?
Yes, I've had enough time, yes.
All right, and he's talked to you sufficiently that you feel solid in your decision in entering this case, entering a plea this way?
Yes, ma'am.
Okay. Because once the plea is accepted, I don't want you to think that Mr. Williams is not going to represent you anymore. But what I'm trying to make sure that you are satisfied with, okay, is that you're satisfied with what he's done thus far, because everything's going to stop related to, whether you did this or not, whether the state can prove it or not, okay? Because by this plea, you're saying, I'm agreeing that they have sufficient evidence. You're not admitting your guilt, but you're saying, okay, I've seen enough, I've asked enough questions, I'm satisfied with the investigation, I'm gonna stop that part and I'm gonna shift my focus into mitigating any potential sentence that this court would make. That's what Mr. Williams is gonna do. You understand?
Yes, ma'am.
Is that what you wanna do?
Yes, ma'am.
Okay. Are you satisfied with this representation?
Yes, ma'am.
Okay. Has anyone threatened you or coerced you to get you to do this?
No, ma'am.
Have they promised you anything?
No, ma'am.
Okay. You understand what my sentencing parameters are? Like what your potential sentences could be?
Yes, ma'am.
What is it?
30 years.
Okay, that's the maximum, that's right. What about the low end?
13 years.
Okay. That's the score. You went over the score sheet.
Yes, ma'am.
Okay. Now, on the form, it says that your lawyer will be seeking a downward departure, okay? Which means he wants potentially this court to go below that lowest permissible sentence that is on that score sheet. You understand that?
Yes, ma'am.
That is a decision I can make. I'm not compelled to make it, right? Like your side. Like you may want that. You may hope for that. Just like the state may want the maximum. I would listen to you. I listen to the state, and I'd make a decision. Do you understand?
Yes, ma'am.
That's the process. And then after that is made, I will pronounce a sentence, okay? And I want to make sure that you understand how final this will be, okay? If I sentence you to 1 second above what you think that you should get, okay? There is no way for you to rewind and go, you know what? They didn't test this, they didn't do that. I want the facts, 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 right? Because this is saying that you are skipping that. You understand?
Yes, ma'am.
So, I want to make sure that you are solid that this is what you want to do.
It is.
Okay. Are you agreeing to pay all the court costs that I've gone over with you?
Yes, ma'am.
We've been talking for some time. I don't think that this is the case, but I just want to confirm for the record. Are you under the influence of any substance, drug, or condition that would impact your ability to understand what's going on?
No, ma'am.
All right. There are 3 warning paragraphs that appear on the 3rd page. Have you gone over each one of those?
Yes, ma'am.
Okay. Do you still wish to go forward, understanding the potential consequences of this plea?
Yes, ma'am.
Have you gone over what a pre-sentence investigation report is?
Yes, ma'am.
Okay. I'm going to order one, and you need to talk to Mr. Williams about cooperating with the Department of Corrections in an effort, but it is a report that will be prepared for sentencing purposes, okay, that I would review prior to, okay?
Yes, ma'am.
Do you have any questions so far?
No, ma'am.
Okay. I'm going to ask the state of Florida to provide a factual basis.
Yes, Your Honor. If this case were to proceed to trial, the state would be prepared to prove beyond a reasonable doubt that the defendant, Justin Golden, on January 25th, 2025 in Duval County, Florida, was driving a motor vehicle, specifically a 2012 GMC SUV. Also in the car was the defendant's less than 1-year-old child, whose initials are PG, as well as the mother of that child, Miss Whitby. While they were in that car, it was in the morning and along Lenox Avenue near McDuff and I-10. There was a argument in the car. Miss Whitby exited the car, and after Miss Whitby exited the car, the defendant picked up his less than 1-year-old child, placed him outside the driver's door directly onto the pavement. The child was not protected or in any sort of child seat and was placed directly on the ground in the roadway where there was no median or other protection. The defendant, upon putting his child on the pavement, closed the door to his vehicle and drove off. The rear driver's side tire ran over his son, causing fatal injuries. The child died at the hospital later on. His acts showed a reckless disregard and culpable negligence and were not otherwise excusable homicide or murder. This was all contrary to the provisions of Section 782.03, subsection 3, and 827.03, subsections 1E, Florida statutes.
Does the defense stipulate to the factual basis for purposes of the plea?
Defense does, Your Honor.
Mr. Golden, is that what you're entering a plea to?
Yes, ma'am.
Okay. All right, the court finds that the state has outlined a sufficient factual basis to support a plea of guilty to aggravated manslaughter of a child. Mr. Golden, is there anything further? Do you have any questions about anything that I've said?
No, ma'am.
Okay. And this is what you want to do?
Yes, ma'am.
All right. This court finds that Mr. Golden's plea to count 1 is entered into freely, knowingly, and voluntarily with a full understanding of the nature, terms, and consequences of his pleas. This court is basing its findings on Mr. Golden's answers under oath and its observations of Mr. Golden. And I will, pursuant to the plea form, order a pre-sentence investigation report to be prepared by the Department of Corrections. And that report takes approximately 30 days in order to complete. And so I need a date from the lawyers for a potential sentencing.
I would be available the week of October the 6th, if that would work for the court and the defense.
Yes, sir. So, Mr. Williams, as you're looking, I would set the 6th to schedule that week because I wouldn't necessarily know my trial schedule. I have, at this point, 3 set that week, 3 trials. But I generally hold sentencing hearings on Fridays. Okay, so I'd be looking potentially to set October 3rd, but I would schedule on, I'm sorry, I said October 3rd. October 10th, I would schedule on the 6th. So if you, I know for a fact I have at least one that week.
I have a trial in Orange County
Okay,
starting on the 6th.
yes, sir. What about the 13th, looking to schedule on the 17th?
There's a good possibility that I will be out the 17th, Your Honor, so if we are looking at not the week of the 6th, I would be asking for at least the week of the 20th.
I have an event on the 20th, October 20th. After the 20th, I'm good.
I can schedule, I have no trials the week of November 10th, so I can give you all a date and time certain that week.
I'm clear that week, so any time that the court chooses.
Don't mind.
All right. How about November 13th, at starting at 1:30?
Yes, Your Honor.
Yes, Your Honor.
Okay, that'll be the date of sentencing. November 13th,
Your Honor, can you give me a second, please?
sure.
He is asking, can we make it instead of 1:30, make it 2 o'clock?
Yes.
All right, thank you, Your Honor.
All right, November 13th, 2 p.m. sentencing. Do you all have an idea of how long?
I expect to have at least the detective from Jacksonville Sheriff's Office present some brief testimony. I expect maybe 1 victim impact statement, and again, depending on the mother, possibly 2.
I'll reserve 2 hours. Is that good?
That's sufficient, Your Honor.
Okay, thank you. See you all then.
Thank you, Your Honor.
You're welcome, and thank you, Your Honor. Okay.
Good
morning, Mr. Davis.
Judge, we have Edward Davis. He's numbers 8 and 9 on the calendar. I'm sorry, Edward Myers.
Okay. Yeah, no worries.